California task force to study and develop reparation proposals for African Americans. Content warning. It contains discussions of racial discrimination, sexual assault, torture, lynching, and other forms of extreme violence. Contains unedited historical quotations and photographs of white supremacist hatred, torture, lynching, autopsy, and other forms of graphic violence.
Just Legal System Chapter 11. Introduction. Discussed in the previous chapters, throughout history, the American government at all levels has treated African Americans as criminals for the purposes of social control. Maintain an economy based on exploited black labor. This criminalization of African Americans is an enduring legacy of slavery. These persisting effects of slavery have resulted in the over-policing of black neighborhoods, the mass incarceration of African Americans, inequities in nearly every corner of the American legal system. History of criminalization began with enslavement and has created what some describe as a caste-like system in America, where African Americans are in the lowest caste of America's racial hierarchy. As the following chapter will show, this criminalization of African Americans has resulted in a criminal justice system that physically harms, imprisons, and murders African Americans more than other racial group relative to their percentage of the population, while constitutional amendments 2 and federal civil rights laws 3 have tried to ameliorate this mistreatment of African Americans. Inequities that remain are so significant that some scholars have argued that, as it relates to African Americans, U.S. society has replaced legal segregation with the criminal justice system. African Americans are more likely than white Americans to be arrested, convicted, lengthy prison sentences. Black adults are 5-9 times as likely to be incarcerated than white people. The experiences of African Americans with the criminal justice system also result in a general mistrust of the civil justice system, where African Americans also face barriers to accessing justice, such as obtaining a lawyer. California, the history of the inequities African Americans experience is similar to the rest of the country's history, although enslavement did not exist on the same scale in California that it did in southern states. Has contributed to the inequities African Americans have experienced and continue to experience. For example, California law once prohibited African Americans from testifying in court cases involving white people. More recently, California's punitive criminal justice policies, such as the state's 3 strikes law, have resulted in large numbers of African Americans in prisons and jails. 10. Although there is very little scholarship on African Americans' experience in the civil legal system compared to scholarship on their experience in the criminal justice system, evidence that African Americans have historically experienced and continue to experience discrimination, such as lack of access to a lawyer. 11. And racial bias among jurors. 12. 11. An unjust legal system. We will discuss the history, criminalization of African Americans and implicit bias. Section 3 will discuss discrimination in policing. Section IV will discuss discrimination in trial and sentencing. Section V will discuss discrimination in incarceration. Section V will discuss the effects of contact criminal justice system. Lastly, Section 7 will discuss the experience of African Americans in the civil legal system. Criminalization of African Americans. Established in the historical scholarship that American society has criminalized African Americans starting with enslavement. 13. Federal, state, and local governments, in order to subjugate African Americans and maintain their enslaved status, African Americans as a way to control them. This system survived the abolition of slavery and the Civil War, and, as some scholars argue, intensified during legal segregation once enslavement ended. Created a new legal and social system to continue to socially control and exploit approximately 4 million African Americans. 14. States passed laws which criminalized African Americans by prohibiting everyday, harmless behavior and punishing violations with harsh penalties. 15. State and local governments then leased out unjustly accused, prosecuted, evicted African Americans to private companies to work to pay off their fines. 16. Between approximately the 1870s and 1940s, this system of leasing essentially created a new form of slavery. 17. In the segregated South, Laws that segregated African Americans treated African Americans as peripheral in American society by physically separating them from white people. 18 Segregation continued to criminalize African Americans by imposing criminal punishments, such as fines and jail time. Violations of laws discriminating against African Americans. 19. From approximately the 1950s to the 1990s, law and order, or tough on crime, political campaigns and the war on drugs resulted in laws that punished African Americans and resulted in their mass incarceration. 20. Codes and the Fugitive Slave Act. American legal system's early criminalization of African Americans through legalized social control and punitive laws stretches back to the colonial era and became more punitive over time, as discussed in Chapter 2. Enslavement oppression of African Americans began with cases in the first American colony of Virginia. 21 In the 1640 case of John Punch. Punished 3 servants running away from their employer. 22 This was one of the first documented court cases involving the rights of African Americans. 23 2 of the servants were white and the third was black, but they all committed the same crime. 24 The court ordered whippings for all 3. The white servant served their employer for 3 more years. 25 While it ordered the black servant, John Punch, to serve his enslaver for the rest of his life. 26 First laws also treated African Americans more harshly than whites. Virginia passed the Casual Killing Act of 1669, which declared that if an enslaved person died while resisting their enslaver, the enslaver would not be considered to have acted with malice, which effectively made it legal for enslavers to kill the people they enslaved. 27 According to one scholar, most of the major slave codes were from 1680 to 1682 as they marshaled previously piecemealed legislation into one code. In 1705, Virginia passed an act concerning servants and slaves. Older laws regarding forced labor in Virginia. This law prohibited African Americans from engaging in activity that white people were free to do, such as resisting a white person. 28 Holding weapons. 29 And leaving their plantation without permission. 30 The laws in Virginia became a model for other southern states throughout the slavery era. 31 The Civil War, federal, state, and local governments criminalized African Americans as a way to control and exploit them. Some scholars argue that this system intensified during legal segregation. Like Virginia, other colonies adopted their own slave codes and ensured that the law subjected African Americans to criminal penalties more harshly than white people. Eventually, every enslaving state had its own slave codes in territories like the District of Columbia. In states like Alabama 33 and North Carolina 34 all fundamentally treated African Americans as inferior to white people. Americans frequently believe that the North was not segregated. This was not the case in reality. In 1849, Massachusetts Supreme Court held that segregated schools were permissible under the state's Constitution. 35 The Michigan Supreme Court held in 1855 that a steamboat company could refuse to sell an overnight cabin to black abolitionist William Howard Day. 36 Courts in southern states even cited to this case, which was in a northern. When ruling against African Americans in other cases involving segregation in schools, streetcars, and public accommodations. Laws and court decisions criminalized African Americans for asserting their human right to be free. The Fugitive Slave Acts of 1793, 37 and 1850, 38 required that all enslaved people seeking freedom by crossing state lines to free states be returned to their enslavers. In 1857, the U.S. Supreme Court held in Dred Scott v. Stanford that African Americans, whether enslaved or free, were not citizens of the United States and therefore did not have the rights and privileges of the U.S. Constitution. 39 There are many documented examples of court laws, court decisions. Documents 40 during this time that demonstrated that the American legal system treated African Americans as inferior, with fewer rights, and who were therefore subject to more punitive treatment under the law. the Emancipation Proclamation and the end of the Civil War, Congress made several efforts to safeguard the rights of African Americans. Congress passed the 13th Amendment, which outlawed slavery. 41 Congress also passed the Civil Rights Act of 1866. Defined African Americans as citizens in order to protect the civil rights of newly freed people. 42 to primarily their physical safety, Congress passed the Ku Klux Klan Act to eliminate extralegal violence against formerly enslaved people. 43 Congress also created the Freedmen's Bureau in order to provide food, clothing, fuel, and other forms of assistance to destitute formerly enslaved people. 44 As discussed in previous chapters, white supremacist Southern politicians rose to power after the contested U.S. presidential election of 1876. U.S. troops withdrew from key cities in the Southern states. Freedmen's Bureau had already been dismantled in 1872 because of Southern political pressure. As a result, these amendments and statutes were largely ignored or circumvented for a century. 45 Codes. States passed the Black Codes and vagrancy laws to criminalize, socially control, and maintain formerly enslaved African Americans in a lower social caste and as a source of exploited, free labor. 46 Though often confused with segregation laws, codes existed to criminalize the everyday activities of African Americans in Southern states during the years immediately after the end of slavery until the Reconstruction Act of 1867. 47 If arrested and convicted of violations, African Americans again had little to no control over their own lives. This provided an opportunity for white Americans in economic and political power to continue using black labor to support the Southern economy. 48 Moreover, and vagrancy laws were a revival of a legal system that existed during the slavery era and further contributed to the social control of African Americans, enabling their economic exploitation. 49 Slavery. White Americans generally believed that free African Americans were suspicious, as white Americans saw free African Americans as masterless, and therefore unhoused or vagrant, and most likely fleeing from the law. 50 In some states, arrested African Americans if they could not prove that they worked for a white employer. 51 They could not change employers without permission. 52 African Americans could not sign labor contracts without a discharge paper from their previous employer. 53 This placed all the power in employers. Slavery placed all the power in enslavers, and left African Americans with little control over their ability to find other work. Virginia passed the Casual Killing Act of 1669, which declared that if an enslaved person died while resisting their enslaver, the enslaver would not be considered to have acted with malice, which effectively made it legal for enslavers to kill the people they enslaved. Code supported the forced labor of black children, as discussed in Chapter 8, pathologizing the black family as part of the Black Codes. Vagrancy laws that declared African Americans who were unemployed and without a permanent residence as vagrants and therefore subject to fines or imprisonment, which criminalized and controlled African Americans. 54 While the Black Codes ended in the 1860s, ex-Confederate states passed vagrancy laws after the end of Reconstruction. 55 All former states in the Confederacy, except Arkansas and Tennessee, passed vagrancy laws by 1865-56 After the police arrested African Americans for minor infractions, they leased them to a private company or a white private citizen who would pay the fine in exchange for the person's forced labor. 57 Under this system, incarcerated people could often never earn enough to repay the plantation enslaver to their satisfaction. The plantation enslaver to continue exploiting black workers for many years. 58 Leasing and Re-enslavement. System known as convict leasing, laws in the U.S. Constitution allowed private entities to force formerly enslaved people and descendants of enslaved people into doing the same work, on the same land. Even for the same people as African Americans would have done when they were enslaved. 59 Black men and boys were arrested on vagrancy charges or minor violations, fined forced to pay off their fine through convict leasing. The convict leasing system was legal because the 13th Amendment allowed forced labor for people who had been convicted of a crime. 60 Therefore, the legal system considered incarcerated people to have few rights because, words of the Supreme Court of Virginia, they were slaves of the state. 61. In some instances, the private citizens who benefited from this system were former enslavers or even former Confederate soldiers, such as the owner of the Angola State Penitentiary land, 62, which was formerly a plantation, as will be discussed below in the incarceration section of this chapter. Conditions under which incarcerated people worked in the convict leasing system were oppressive. Unlike in the slavery era, lessees had no incentives to keep incarcerated people healthy or alive. The convict leasing system was worse than slavery. 63 Working and living conditions for incarcerated people were dangerous, unhealthy, and violent. 64 Archaeologists recently discovered a mass grave of incarcerated people's remains in Sugar Land, Texas at the Bullhead Camp Cemetery that was once part of the Central State Prison farm owned by the state of Texas. 65 In this mass grave, on land that was once owned by enslavers and their descendants, found 95 bodies of men and boys and possibly one woman, almost all of whom were African Americans, who were participants in the state-sanctioned convict leasing system, which existed in Texas between 1871 and 1911. 66 Historical documents showed that incarcerated individuals at this plantation frequently died from heat stroke, malnourishment, extreme physical activity for extended periods of time, and disease. 67 Further, incarcerated individuals had occupational injuries and wounds from gunshots and corporal punishment. 68 Convict leasing, such as what occurred in Sugar Land, Texas, existed throughout the American South. 69 Further, a variety of individuals and businesses used convict leasing. 70 Such as Tennessee Coal Railroad Co., which U.S. Steel owned. 71 Scholars indicate that convict leasing gradually ended by around the 1940s. 72 As each state stopped leasing convict labor to private individuals and business, known as convict leasing, state laws and the U.S. Constitution allowed private entities to force African Americans into doing the same work, on the same land, and even for the same people as when they were enslaved. Children working in the fields. 1903. 372. Chapter 11. Just legal system. Segregation and racial terror. During the era of legal segregation, Southern state and local governments implemented a system of legalized social control to separate Black and white Americans as discussed below. Were a legacy of slavery because they criminalized African Americans in a post-slavery era by mandating their separation from white Americans and provided for criminal punishments for any violations. The United States Supreme Court case Plessy v. Ferguson upheld the rule of separate but equal, legalized laws that required the separation of African Americans and white people in nearly all public places such as parks, businesses, transportation. 73 Laws provided for criminal penalties such as fines and imprisonment through the legal justice system, only for African Americans who violated segregation law. 74 As Chapter 3, Racial Terror, discusses, government actors and private citizens routinely punished African Americans who violated these laws, or even appeared to be breaking racial norms created by white people, through extrajudicial means such as lynching, racial massacre. Social fear-mongering. Lynching also contributed to the popular belief among Americans that Black people were assumed to be guilty. 75 White lynch mobs murdered Black suspects who were later found to be innocent. 76 Sometimes these murders occurred for no reason at all and at least one targeted a pregnant woman and born child. 77 White mobs often framed the lynching as a method of self-defense against African Americans who were portrayed as dangerous criminals who posed a threat to white society. 78 Segregation laws were legal until the 1950s and 1960s when landmark such as Brown v. Board of Education and laws like the Civil Rights Act of 1964 found them unconstitutional or made them illegal. 79. Americans often associate segregation laws as a Southern phenomenon. The legal system also discriminated against African Americans and treated them as inferior after the Civil War through court cases and laws. 80. This discrimination is particularly apparent in a line of cases involving the rights of African Americans on railroad cars. 81. In 1867, Pennsylvania Supreme Court ruled against Mary Miles, who refused to sit in the colored-only section of a streetcar. 82. Courts in southern states, such as the Florida Supreme Court. 83. And the Tennessee Supreme Court. 84. Later cited the Miles case in which the courts decided against African Americans who sought to sit in the whites-only sections of streetcars. 85. It is also well established that, from the 1880s to 1960s, northern states had laws that allowed segregation in schools and public accommodations. 86. Crime era and the war on drugs. The civil rights movement ended legal segregation and made explicit discrimination against African Americans in the text of court cases and statutes illegal. However, scholars argue that legalized social control continues today in the legal system despite existing civil rights laws and regulations. 87. These scholars argue that the incarceration of African Americans, particularly black men, occurs in our legal system in two stages. 88. First, police, prosecutors, and judges have significant discretion as to who they may stop, search, arrest, and prosecute even in a supposedly racially neutral system. 89. During this first stage, implicit bias, which the previously described history of America's criminalization of African Americans created, affects decision makers and results in high numbers of African Americans in prison. 92nd, as discussed above, several court cases prevented legal challenges to racial discrimination. 91. Laws in the decades during and after the Nixon administration provided for increasingly harsh penalties on criminal defendants that resulted in a higher likelihood of African Americans in prison than white Americans. 92. During the post-civil rights era, both Republican and Democratic politicians ran on tough on crime, or law and order, political platforms that popularized especially punitive criminal laws, particularly laws prohibiting drug sales, distribution, possession, and use, to gain support from voters. 93. John Ehrlichman, been Nixon's domestic policy advisor, explained campaign in 1968, and the Nixon White House after that, had two enemies, the anti-war left and black people. You understand what I'm saying? We knew we couldn't make it illegal to be either against the war or black, but by getting the public to associate the hippies with marijuana and blacks with heroin, and then criminalizing both heavily, we could disrupt those communities, we could arrest their leaders, homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did. 94. Mobs murdered black suspects who were later found to be innocent. These murders occurred for no reason at all, and even targeted black children. White mobs often framed the lynching as a method of self-defense against African Americans who were portrayed as dangerous criminals who posed a threat to white society. What Ehrlichman describes, and many scholars have noted, politicians essentially sought to appeal to the backlash against the civil rights movement by supporting punitive criminal laws. 95. Democratic politicians such as President Bill Clinton also ran on tough on crime platforms during his campaigns and supported punitive laws once in office. 96. Campaigns often relied on the negative stereotypes of African Americans as criminals built by the previous 3 centuries of American law and order. H.W. Bush produced a series of advertisements for his 1988 presidential campaign against Democratic nominee Michael Dukakis that featured a black man named William Horton. These advertisements exploited the stereotype of black men as predators and rapists of white women. William Horton was murdering a white woman and stabbing her partner while on furlough through a weekend pass from prison. The furlough was granted through a Massachusetts program when Dukakis was governor of Massachusetts. The advertisement primarily consisted of a voiceover summarizing Horton's crimes and a mug where he looked particularly threatening. The advertisement also nicknamed Mr. Horton, Willie, 97 the Willie Horton. Advertisements inaccurately portrayed bipartisan-supported furlough programs. These programs were used in all 50 states. Afforded incarcerated individuals the opportunity to leave prison for a certain amount of time to visit family, search for employment, and prepare for life out of prison. 98,000 of incarcerated individuals safely took advantage of furlough programs in the nation. Horton was the rare tale of a disaster. 99 politicians entered office, racist political campaigns morphed into racist policies. In 1971, President Nixon declared a war on drugs, 100. In the speech on it, he described drug abuse as public enemy number 101. This marked the beginning of the federal government's effort to fight illegal drugs by significantly increasing penalties, enforcement, and incarceration of people who possessed, distributed, and sold illegal drugs. 102. Rather than treat drug use as a public health issue, American government chose to treat illegal drug use as a criminal justice issue. 103. Federal and state governments chose to punish drug users rather than offer medical help. The war on drugs, which continues today. 104. As a cause for the high numbers of imprisoned African Americans, evidence exists to suggest that African Americans use drugs at approximately the same rate or less than white Americans. 105. Decades that followed Nixon's announcement initiating the war on drugs, Congress passed laws that harshly punished criminal defendants. During the presidency of Ronald Reagan, Congress passed the Anti-Drug Abuse Act of 1986. Allocated $1.7 billion to the war on drugs and provided for mandatory minimum sentences for various drug offenses. 106. Included far more severe punishment for the distribution of crack cocaine in a solid pellet form, than the punishment for powdered cocaine in a fine powdered form. Even though there is no scientific difference between these forms of the drug. 108. The law established a 100-to-1 disparity in the punishment created for the distribution of crack and powdered cocaine. 109. Distribution of only 5 grams of crack resulted in a minimum 5-year federal sentence. 110. Meanwhile, distribution of 500 grams of powder cocaine resulted in the same sentence. 111. 1988, Congress added even harsher penalties to the law. 112. The change allowed public housing authorities to evict any tenant who allows any form of drug-related criminal activity to occur in or near public housing premises. 113. And eliminated many federal benefits, such as student loans. When convicted of a drug offense. 114. An arrest is not required to evict entire families from public housing, as long as an agency employee. Chapter 11. That a household member or guest has engaged in drug-related activity. 115. Scholars have argued that these policies perpetuate residential segregation. 116. And state governments chose to punish drug users rather than offer medical help. The war on drugs, which continues today, is a cause for the high numbers of imprisoned African Americans, as evidence exists to suggest that African Americans use drugs at approximately the same rate or less than white Americans. Also expanded the use of the death penalty for serious drug-related offenses and imposed new mandatory minimums for drug offenses. 117. This Anti-Drug Abuse Act has had a disproportionate effect on African Americans because African Americans have more commonly used crack cocaine rather than Cocaine 118. One study found that the probability that a black man would enroll in college dropped 10% after the passage of the Anti-Drug Abuse Act of 1986. 119. Another showed that close to one-third of individuals arrested for drug possession in the U.S. are black adults. 120. Scholars argue that other laws passed during this time intensified drug law enforcement by incentivizing local law enforcement to stop, search, prosecute, and/or incarcerate large numbers of people during the presidency of President Bill Clinton. Passed the Violent Crime Control and Law Enforcement Act of 1994 or the 1994 Crime Bill, which made several changes to the law, such as increased federal penalties for many crimes, made a variety of offenses federal crimes. Federal funding in ways that encourage the growth of a more punitive criminal justice system. 121. Scholars have argued that this bill contributed to the exponential growth of the prison population in the United States in part by promising $8 billion to states if they adopted truth in sentencing laws. Required that incarcerated people serve at least 85% of their sentences. 122. To name another example, passed the Comprehensive Forfeiture Act of 1984, which, as some scholars argue, is police to engage in over-policing because it allows them to keep assets of people engaging in criminal activity. 123. Numerous studies around the country have found that the police are more likely to seize money and property from black defendants. 124. Implicit bias. State and local governments intentionally and methodically criminalized African Americans, regardless of race. To associate African Americans with crime. This enduring legacy of slavery has resulted in an American society that is biased against African Americans. Psychologists have documented, for almost 60 years, that the stereotype of African Americans is violent and criminal. 125. This association is not only strong, also appears to be automatic, unconscious. 126. Other studies show that in cases involving a white victim, the more stereotypically black a defendant is perceived to be, the more likely that person is perceived to be dangerous. 127. New but growing body of scholarship shows that police officers are frequently biased against African Americans. 128. New policing technologies may perpetuate how police treat African Americans because they use algorithms that replicate human biases. 129. California. Like courts in southern states and northern states, California courts and the legislature also discriminated against African Americans throughout history. 1874, the California Supreme Court upheld school segregation in San Francisco. 130. In 1919, the California Supreme Court decided a case against a black couple, the Garys, fought to keep their Los Angeles property against a racially restrictive covenant. 131. These cases show that California courts were actively involved in legitimizing discrimination against African Americans. To court cases, California also passed discriminatory laws as discussed in other chapters. In 1850, state prohibited marriage between black and white Americans. 132. And prohibited African Americans from testifying in civil and 133 criminal court cases that involved white people. 134. The California Supreme Court upheld this law prohibiting testimony from African Americans. 135. Like other states and the federal government, California also passed its own fugitive slave law in 1852. 136. Much like southern states, California also had vagrancy laws. 137. Recently, California passed the Mulford Act on July 28, 1967, which made it a misdemeanor to carry firearms in public. 138. The bill was in response to the Black Panther Party for Self-Defense, which was formed in Northern California in 1966 and organized legal armed demonstrations in the state to support and protect African Americans. 139. In February 1967, Armed Panthers escorted Malcolm X's widow Betty Shabazz to the Malcolm X Grassroots Memorial in San Francisco 140 in April 1967. Panthers led a protest against a Contra Costa County sheriff who killed a young black man 141. It was against this backdrop that State Assemblyman Donald Mulford introduced legislation to ban the carrying of firearms in public places 142 in response to the proposed legislation. Panthers walked inside the assembly chamber at the California Capitol while carrying firearms to protest 143. Although Assemblyman Mulford had denied that the legislation was racially motivated after that demonstration, Assemblyman Mulford added a provision to Assembly Bill 1591 that would also include a ban on carrying loaded weapons in state buildings 144. California has also imprisoned black activists Romaine, Chip Fitzgerald and Geronimo Pratt, both influential members of the Black Panther Party, were sentenced to life in prison for separate murders in 1969 and 1971. Effectively 145. Even though by 1990 there was substantial evidence indicating that Geronimo Pratt was framed, the California Supreme Court refused to overturn his conviction at the time, and a Los Angeles County deputy district attorney argued against Pratt's parole, stating, "He is still a revolutionary man." 146. While Fitzgerald remained in prison for over 51 years until his death at age 71. 147. Pratt was eventually released in 1996 after documents confirmed that the government's key witness was an undercover police operative who posed as a member of the Black Panther Party. 148. Advocates argue that other black political activists currently imprisoned in California should be considered political because they have been denied parole as a result of their political affiliations. 149. 1984, Congress passed the Comprehensive Forfeiture Act, which allows the police to keep assets of people engaging in criminal activity. Numerous studies around the country have found that the police are more likely to seize money and property from black defendants. 11. An unjust legal system.